to deliberate and consider lesser charges, layers of lesser charges than the double homicide and the alleged attempted homicide. Do you think that confused the jury in any way?
No, they never got to it. They never got to it. And here's why. If they determined that the state had not disproven self-defense, they didn't go on to the lesser charges. Self-defense was the end of each alleged victim's crime. And so if you recall, well, you won't recall, I do because I'm a lawyer, there was a lot of confounding jury discussions and jury instruction discussions, but I'll say this. The judge realized that it had to say that if they found that the state had not disproved that he acted with the privilege of self-defense, they were not to go on to the lesser charges. That was the case. That was the issue in the case from the day he was charged, and it remained the issue for the jury. I'm almost certain they never got to any lesser charges.
There were 2 mistrial motions filed, and those go away now? The judge has not ruled on those.
They are moot. The verdict renders them moot because jeopardy has attached. When the judge enters judgment on the verdict on the motion of the defense doesn't need its motions decided for mistrial. A mistrial is saying we didn't get a fair trial. I don't think you're going to hear that from anybody on the defense side this year, so I don't think you need to worry.
So you think the state overcharged on this?
I do. They overcharged in 2 ways. First, they knew there was going to be a lot of video, but because of the milieu in which the crime occurred shortly after the Jacob Blake shooting, there was a very great rush to charge. There's no question that was true. And instead, since there's no statute of limitations on first-degree intentional homicide, and there's long ones on the other counts, they could have waited, reviewed all the evidence, and come to a better decision. I think in every one of these shootings, they could have brought a criminal charge, but I don't know that any of them would have been intentional first-degree homicide. But, politics being what it is, and the district attorney is elected, sometimes they have to act in what they consider to be the best interest of the community. And I have no doubt in my mind that the charge was brought quickly in order to make sure that worse disturbances on the street did not ensue. Now, what happens tonight? Well, I hope people stay calm and realize our system works.
Yeah, the whole issue surrounding the trial was provocation versus self-defense. The jury clearly agreed that it was self-defense. Does it surprise you that that all of the charges, it was a unanimous decision, not guilty on all of the charges, that there were no repercussions at all for the loss of a life?
Okay, let's stop right there. There are massive repercussions. Do you remember?
I mean, you know what I'm saying.
Rittenhouse on the stand?
Yeah.
There are no legal
consequences
in the criminal court. Don't forget, O.J. was sued for millions, okay?
Right.
Somebody can sue him if they want. This was nothing more and nothing less than a finding that the state had find him innocent. Let's remember that. They said the state had failed to prove it beyond a reasonable doubt. Now, you mentioned provocation. Let me just tell you something about that. It's crystal clear in this case that the provocation, in my view, was a Hail Mary, or even worse, an onside kick, because the state had nothing to really counter the video evidence and the testimony of eyewitnesses. So what they did was they tried to use a technicality and come up with this idea that walking on the street with an AR was provocation. Here's the problem. There were people doing it today, and nobody got arrested for any kind of disorderly conduct. It is your right to carry openly in Wisconsin. Mm-hmm. So that was really a last gasp jury instruction. My guess is the prosecutor was thrilled to get it, and maybe that's why they had 3 days of deliberations, but I don't think he truly believed he was going to win on that issue.
If you were the state, how would you have presented this case differently?
How would I present it differently?
What kind of charges would you?
Since I was a prosecutor. Let me put it this way. I would have taken the time to investigate it properly. I would not have charged him right away. Where was he going to go? Home to mom. This isn't an international financier like the infamous Mark Rich, who was pardoned by President Clinton, who could run to a foreign country and hide. He lived in Kenosha and Racine, and that's where he was going to be. And when they told him to come to court, he was going to come to court. They should not rush in on a case this serious if they want to do it right. You don't have to. When I was a state prosecutor, we took our time on homicide investigations because you could bring them whenever. You know that. You read about cold cases every day from 30 years ago.
Okay, I think we lost our.
We'll do it that way.
We're losing your connection there, Chris.
I'm sorry. I apologize. Let me take it off speaker. Maybe it'll work better.
We can hear you now.
We're looking, Chris.
Okay.
We're
Can you hear
looking-
me now?
Yeah.
We've got
Great.
you. We're looking at a live picture outside of the Kenosha County Courthouse.
Yes.
All appears to be calm right now, at least from the picture, the vantage point that we're looking at. But this is a case it was a very polarizing case that sort of magnified political agendas on both sides, on the left and on the right. What do you expect to happen from this point forward now?
Well, first of all, nothing further will happen in this case because it's over. If you're asking me for, if you will, a societal overview, all I'm going to tell you is I'm going to say a prayer that people realize that all of the violence that could ensue will not advance anyone's agenda, but will continue to drive this country further apart. And let's remember that people did lose their lives here. And as a result, we have to honor them. Those lives had value. And we should not, therefore, use the old biblical analogy of an eye for an eye and a tooth for a tooth, because that's not our system of justice, and it's not the Bible's either, by the way. It's just a famous line. I think what everybody has to remember is that if their son or daughter or brother or husband or father found themselves in the same situation, you would want them to have every right and every opportunity at a fair trial this way. If you didn't get it, you would feel as if you were railroaded.
Chris, thanks for being with us today, for your insights, and let's all hope for a peaceful night in Kenosha this evening. Chris Van Weer.
Let's all say a prayer for that.
Absolutely.
Thank you.
Chris,
and everybody
thank you.
should, you bet. Take care. Bye-bye.
All right. Jessa Nicholson has been with us all along this trial. She's joining us now live. Jessa, your reaction?
Well, I was surprised they were back today. It's going to go into next week. But, you know, this is something that people that watched the evidence portion of the trial were kind of predicting. I think the last few days we've gotten away from that was the general public sentiment about this prior to deliberations because the jury's been out for so long. But I can't say I'm entirely surprised.
But having listened to all of the testimony in the entire case, do you think the jury reached the right decision?
I think the jury reached a reasonable decision. And to me, I don't see this case as having been as clear cut as either side argued it. I think that the prosecution made Kyle Rittenhouse out to be a very cold-blooded and deliberate murderer. I think the defense made him out to be a bit of a folk hero. I think that he was a kid in a really dangerous situation who took steps to act in his own defense. I don't think he's a hero. He didn't save other people. At most, he saved himself. I think the issue here is the jury couldn't say beyond a reasonable doubt that self-defense wasn't an issue. And I know I'm using double negatives there, but that's really what we're talking about. This verdict represents the jury saying the state didn't disprove self-defense. That's different than a verdict of absolute innocence, I think. I mean, there's no such thing as a verdict of absolute innocence,
right.
But what the verdict says is simply that the prosecution was not able to overcome that very high burden.
Some critics are saying that the state may have overcharged in this case. What do you think?
I think that the count relating to Mr. Huber was overcharged. I think that could have been charged out as a second-degree intentional homicide. But of course, the jury was given lesser included offenses and they rejected those.
Do you think they even got an opportunity to consider those? I guess there's no way to know that for sure, is there?
Well, so the way that they're instructed to work, right, is they're supposed to start with the top count. And if they can't agree on the top count that the defendant is guilty, or if they agree that he is not guilty, then they have to kind of run down and look at it. And so I assume that they talked about all of it, particularly given the length of time that they were out. I assume that they did work through it, and they probably just got to the point where nobody was ever going to reach 12 of them agreeing for guilt on any of the counts. So I bet they looked at all of the counts. They would have been trying to work through those instructions. It wouldn't have stopped just with we don't think he's guilty of first-degree intentional homicide, so we're going to come back full acquittal. They would have done the analysis on everything.
It seemed to come very quickly this morning, that the verdict coming down. People, you included, thought it might come a little later on.
Yeah, I was expecting it next week. And I did start seeing kind of rumors on the internet, which, put as much faith in that as you want to, saying that the jury intended to come back around 10 a.m. I'm not sure where people were getting that, but I discounted those as well. I thought we were going to I thought they were going to bring them back Saturday. Well, so I'm a little surprised it came back this early today.
You were very articulate yesterday talking about how everybody's trying to read the tea leaves and figure out when a verdict would be reached. But in your experience trying cases, does the jury normally come back with a verdict and the judge reads it right away? Or is there a little bit of time to digest that before the verdict is read? Because I think it caught all of us a little bit off guard today.
So I will tell you, as a lawyer who sits and waits for it, in my head, I always kind of refer to it as like this death march of the jury hands, the jury foreperson hands the verdict.
Did we lose Jessa?
I think we lost Jessa.
Hannah, did we lose Jessa? Oh, there she is.
Okay,
you're back.
You're back,
Sorry
Jess.
about
Sorry.
that.
Go ahead.
Oh, I was saying that when you're one of the lawyers waiting, that walk from the jury foreperson to the judge by the bailiff takes about 7 days. I mean, it takes forever. But in reality, it only takes a few minutes. And that is very common, that they do that walk from the foreperson to the bailiff to the judge, and then we read it right away.
Mr. Rittenhouse had quite a reaction when the verdict was read. Seemed to break down again. How do you think the rest of the community is going to react?
I am hopeful that everything remains calm. This is a case that was very divisive. I think everyone is expecting that there are going to be a lot of people who react negatively. I think that would have been true regardless of which way this went. So I expect there will be protests. I hope there isn't violence, but I expect there will probably be public outrage.
What ripple effect, if any, do you think this verdict is going to have on future cases?
I think that some of the optics of this trial might cause people to be more careful with some of their off-the-cuff comments that occur when a trial's being live streamed. I think this judge got a lot of media critique for things that he said in passing or that he did not necessarily in front of the jury. So I can see judges, when they have high-profile cases like this, trying to make sure that they're not making those errant comments more. My hope would be that the prosecution would take a look at this verdict and look at some of their conduct throughout the trial and self-reflect and see if they could make different choices about the way that they approach evidence.
We talked earlier about the fact that the defense had filed several motions for a mistrial in this case, and the judge never ruled. Do you think he was waiting for the jury to come back with a verdict? Because now, at this point, that's moot, right?
Well, he said that explicitly yesterday. He said, I will not rule on these unless there is a guilty verdict, and then I'll make a ruling.
Interesting.
Oh, that's interesting, yeah.
All right.
I continue to believe that was not in the public safety interest, but it doesn't matter. It's a moot point at this point.
All right, Jessa, thank you very much for all of your work throughout this week. It's been a pleasure. And once again, Kyle Rittenhouse, 18-year-old Kyle Rittenhouse, found not guilty on all charges filed against him. After 25 or so hours of jury deliberation and 3 weeks of trial, Kyle Rittenhouse, not guilty. That's our time for now. We'll have continuing coverage all day long on channel3000.com and on our Channel 3000 app, and a complete wrap-up coming up on Live at 4. In the meantime, have a great afternoon.
We now join our regularly scheduled program, Already in Progress.
Oh my God. You? And Sheila?
I did not know how crazy she was, I swear. I should have told you.